You took a beautiful life that was starting to blossom into a beautiful woman. And for that, I hope you stay in jail for the rest of your life, because I have to go on with my life and her father without our daughter.
Devastated mother speaking out after her daughter's life is taken far too soon. Well, today the prosecution resting in the case of a 71-year-old man on trial, Theodore Wafer. Wafer, a retired cop, is facing second-degree murder and manslaughter charges after police say he shot and killed 19-year-old Renisha McBride. Authorities say McBride's blood alcohol level was 11 times the legal limit, and she had been smoking marijuana before her car was involved in an accident. Police say she stumbled onto Wafer's front porch and knocked on the door in the early morning hours looking for help. Police say Wafer used a 12-gauge shotgun to fire through the door, killing Renisha, who was less than 3 feet away. Wafer first said that he fired the shots in self-defense because he thought someone was breaking into his home. However, the self-defense claims were called into question after police dash cam audio from the scene was released. And you can hear Wafer saying that he didn't think that the gun was loaded. Now, many are trying to compare this case to the man on your screen, George Zimmerman, and obviously the Stand Your Ground case in Florida. That, of course, where the neighborhood watch volunteer shot and killed an unarmed teen, Trayvon Martin, after following him through the neighborhood after Martin left a local convenience store. I want to bring in our legal panel right now. Jim Kasouris, criminal defense attorney in Manhattan, lecturing at New York Law School and a visiting professor at the University of Birmingham in England. Doug Von Oist, a founding partner of Karsten Von Oist, focusing on corporate misconduct, selected by the Legal 500 as one of the most influential trial lawyers in the whole country. And Mayo Bartlett, attorney and former chief of the Bias Crimes Unit at Westchester County District Attorney's Office, and involved in a lot of high-profile civil rights cases as well. And Mayo, first let's start with you, and then I want to get from all you guys how you would or wouldn't handle this case. But do we have clarity, let's say with Michigan, and then more broadly, where does someone's rights start and stop if they're on their own property and there's a rap on the door? Can you basically do whatever you think is reasonable in your own mind if you think that somebody's coming into your home here? Can you take any actions that you think are justifiable?
You can't really take any action. I mean, it has to be a rational action, a reasonable action. If someone's simply knocking on your door, then in theory, if you could do anything, every Halloween, people could just unload shotguns through the door and kill people and then claim they were in fear. And I think that, in particular with this case, one of the things you have to pay attention to is the fact that this gentleman was a former law enforcement officer. So he, in particular, would be in a better position to know that if, in fact, his house was being invaded and there was no immediacy, the door is just being knocked on at that point. If he thought something suspicious was happening, didn't involve people trying to actually break his door down and shoot him at the moment, you call police, you call 911, you tell them that you're concerned, you let them know what you're dealing with. But here you have a young girl knocking on the door. She's not doing anything other than that, and then he had an opportunity basically to unload a gun through the door, by the way, not after the door is open, and take a life. I think that really at that point the recklessness is just astounding.
Does it matter, Doug, that it's 4 in the morning? Does it matter that she's drunk and high and this is, way above the limit? Do any of those factors mitigate at all what he can say, it's not the fog of war, but 4 a.m. is different than 4 p.m.?
All the factors are important. When you look at this, you're looking at, and you mentioned a reasonable man. What would be reasonable? In the middle of the day is different than the middle of the night. You know, breaking down the door is different than knocking on the door. So all the factors become very important in a case like this.
Jimmy, how much, if you're the counsel in this case, does the stand your ground law in Florida and other places confuse this? The one thing that came out of the trial beyond all the obvious was so many people don't know where the line is anymore. Remember, not long after that, the guy shoots a guy in a movie theater because he's, I guess, texting or whatever, or he's on a cell phone during the previews, and then he claims self-defense. There's this perception that you can say self-defense for anything as long as you claim that you feel threatened. And that's the guy, again, a former law enforcement official, who fired that gun in that Florida theater. Are we confused where the line is anymore or no?
You know, the verdicts may make it sound like we're confused, but we're not. Look, the law in Michigan is very clear. You are entitled to use deadly force if you honestly and reasonably believe it necessary to prevent imminent death. Importantly, in Michigan, there's a presumption that the shooter honestly believed that there was a risk of imminent death if the person shot was in the process of breaking into the dwelling. To me, I think to the viewers, the law is pretty clear. And I do not see this in any way comparable to the Zimmerman case. There's a knock on the man's door. Granted, it's 4 o'clock in the morning. Do the words, "Who is it? What do you want?" come to mind? If she's not breaking in. Now, if she was breaking in, if he saw somebody trying to pry the door open, if she was breaking the window, if there was evidence that she was trying to break in, there's a very clear line that he can use deadly force, and he's presumed to think that his life is in danger. It doesn't seem to be what we have here.
Now, let me ask you some trial questions here. To this point, and you've got the prosecution basically resting at this point, we haven't heard the issue of race. White guy shoots a white 71-year-old man, shoots a young black woman. I don't know what the defense will say on this, but I don't think they're going to want to stress this, and I don't know the jury makeup, but you got to figure, even if nobody mentions the word race, even if no one says the word black or white, it's at the forefront of the jury's mind. Race will matter in this case, won't it?
Again, it's a case where race really shouldn't matter.
But it will, right?
It may, and it depends on who you have on your jury. If you have a jury that's really taking their oath seriously and they listen to the instructions of the court, race really should have nothing to do with it, because
But
the reality
isn't
is...
it a legitimate question to say, wait a second, if that girl was white knocking on the door, right, would he still have pulled the trigger?
Well, but let's take a step, if we take a step back, let's assume that if she was white, he would. Well, then at that point, it should be equally troubling to everybody in society, because now you have to think, well, gee, if that's my daughter who's a white young lady and she needs help and she knocks on his door, she gets killed.
I'm just saying, you've been in front of more juries than I'll ever see, even if I watch Law & Order every day. Okay, but the point is to you, when you have that elephant in the room and it doesn't get spoken about, you gotta, I would assume, figure it as part of either the defense or the prosecution, how you communicate to the jury, right?
I think you're correct. And one of the things is, it's unfortunate because it's troubling that when you have a jury, if you have a jury that's perhaps predominantly African American, it may enter into their mind. If you have a jury that's perhaps majority Caucasian, it may enter into their mind. And that's how you end up with verdicts that are go against the evidence, because people start to sympathize and they start to put the defendant in their place or the victim in their place instead of simply looking at the case objectively. And if we do that, we're much more likely to get it correct.
I'm already over the time on this one, but one last question for both you guys. You're the defense right now, and the prosecution's laid out a pretty compelling case. You're just trying to pick off one juror at this point, right? You're not, right? You're trying to find one guy, you're trying to hang this thing. Do you put your client on the stand?
In this case, I would never put this guy on the stand.
Even if it looks real bad at this point?
Listen, he's told one story, and the camera or the audio picked up a different. Once you have a discrepancy in the story like that, it's going to be whether he's lying or not. And quite frankly, I don't see how the guy could withstand that.
Got to put him up.
Yeah.
You got to put him up. You're losing at this point. You have got to put him up. He's 71 years old. He's a former cop. It's what he reasonably believes. And you know, with these affirmative defenses where it depends on what the defendant believes, you got to put him up there, and he's got to say, I couldn't see black, white, red, or orange. First of all, it was dark. And then I believe this, that, and the other thing. He's got to sell it. He's got to.
He doesn't look like he's 71 years old.
No,
no, he doesn't.
No, he really doesn't.
When we come back, Big Brother is watching. I've talked about it with these three guys before, but imagine for a second, and this isn't a hypo, authorities were keeping track of your every move, where you go to the grocery store, which doctor you go to. Again, this is happening in our backyards, everybody. It's happening as we speak with the help of license plate tracking across our region. And my question is, forget about whether you like it or you don't. How is this legal? Our legal panel is going to weigh in on that and much more after we come back.